What's up, everybody? Feels like old times here, talking Johnny Depp and Amber Heard. I just finished recording a video breaking down one of the newest filings in Amber Heard's insurance lawsuit cases. So you have to check that out. It'll be posting probably tomorrow night, Saturday night, because I was not going to have enough time to handle both of them during this live and answer all of your questions and get into the nitty-gritty of Johnny Depp's appellate brief. So we are going to do that today. We are going to deep dive into the appellate brief. We're going to read the entire thing together, talk about which arguments may be surprising, which ones are not, which ones I think are give him his best chance to win, how this may differ from Amber's attorneys and how they argue in court and in the appellate brief. But it is an interesting brief nonetheless, and you all wanted a breakdown of it, so that's what we're doing. It seems like everybody has already done their breakdown, but you still want more. You guys are savages, so we are here to give you more, to break it down together, and to answer your questions as always. So hit that like button if you haven't already. So whoever is interested in my take on the appellate brief can come join us this afternoon. It's Friday. It's beautiful. It's almost time for the weekend. Let's dive in to this appeal together. What's Johnny have to say? So we already know what the issues are, right? We did a video on that. But now we get the actual arguments. We get the case law. We get the facts with the case law. Thank you, Andrea. We're going to just not go through the statement of the case. So we're going to go through this statement of the case here. We're going to skip the statement of the case, get to the introduction. We all know what happened. We all know they went to trial. We all know what the issues were. We all know Johnny Depp won, and we all know we're here appealing. We also know that Johnny Depp and his team said they would not have appealed, but for Amber Heard appealing. And I kind of said all along, I don't know how Amber Heard won, number one, on this issue with Adam Waldman's statements. Number two, I thought it was his best opportunity for appeal. And number three, it would have way longer lasting effects if this was upheld. It has already been referenced by other judges, including in the Gabby Petito case here in Florida, that a lawyer's words can be attributed to their client even for tortious reasons. And I think that's incorrect. But let's get to what he argues and why, and we can talk through it together and, of course, answer your questions. The jury's emphatic favorable verdict on all three defamatory statements alleged in his complaint fully vindicated Mr. Depp and restored his reputation. Indeed, Mr. Depp prevailed in the trial court on virtually all material issues, and the verdict of the jury and judgment of the trial court represent an intelligent and well-reasoned decision on the merits after a full and fair trial and should largely, though not entirely, be affirmed. So what's interesting about this is they know that there are issues that they want to appeal, but they don't want to make it seem like the whole trial was bad. We need to redo the trial because of all the mistakes that were made. They do not want to make it seem like that at all. So they have to butter everybody up, including the trial court and the appellate court, to say this was really great and we think the jury got it right for the most part. However, the trial court was confronted with a number of novel and complex legal and factual issues. And although the trial court decided the vast majority of those issues sensibly and correctly, a few rulings were erroneous. That's a with all due respect. You did a great job, but nobody's perfect, Judge A. Mr. Depp does not appeal the verdict on his claim, of course, because he won and got millions of dollars. Nor does he appeal the verdict in his favor on two of the three Waldman statements. Whoa, looky there. He's not appealing anything he won, which, in case you didn't know, you actually can appeal even if you win. If you think you didn't get enough money or if you think something went wrong, even though you won, you can still appeal causes of action that you did win. But his appeal relates solely to the Waldman statement on which Ms. Heard prevailed, a statement in a Daily Mail article dated April 27, 2020. The judgment in Ms. Heard's favor on that lone statement is erroneous. Ms. Heard's claim was fatally flawed, and the trial court should have granted Mr. Depp's motion for summary judgment and his motion to strike the evidence for 3 reasons. First, Mr. Depp cannot be held liable for Mr. Waldman's statements as a matter of law, meaning it should not have ever even gotten to the jury. Ms. Heard sought to hold Mr. Depp liable for the April 27th Waldman statement on a pure theory of vicarious liability. We'll get into what that means and why that's a little different than just saying what he said was wrong. Contending that Mr. Depp was liable merely because Mr. Waldman had been retained by Mr. Depp as his attorney and was therefore his agent. But as a matter of law, Mr. Waldman is an independent contractor whose allegedly tortious conduct is not automatically attributable to Mr. Depp. Indeed, a wealth of authorities supports limiting a client's liability for allegedly tortious conduct by an attorney, and the court should impose that same limit here. And you'll hear he brings it in from all sorts of different jurisdictions. So first, he's saying that Waldman was not an employee or an agent for this particular definition of an agent of Johnny Depp. Instead, he was an independent contractor and therefore can't be held liable for the tortious comments of your independent contractor. But secondly, because Ms. Heard proceeded against Mr. Depp at trial on purely a vicarious liability theory, she was required to present evidence that Mr. Waldman committed each element of the tort of defamation, including that he acted with actual malice. And there's no evidence of Mr. Waldman's actual malice that was presented at trial, so the judgment against Mr. Depp cannot be sustained. We're going to dig into this more, but that's exactly what I said. And that's what was so important about the objection attorney-client privilege, objection attorney-client privilege, and it was sustained every time. They didn't get into the fact that Adam Waldman knew the statements were false or he acted with reckless disregard to the truth. He actually had record evidence, you could argue, as to why he thought they were actually true. And we'll talk about whether or not lawyers should be allowed to say in press conferences or in the Daily Mail that their client is right and the other client is wrong. And the other client is just trying to extort them or have some hoax or make something up or the other party is lying. Are lawyers going to not be allowed to say that anymore? Or if they go lose and settle the case, is that going to be defamation? Certainly hope not. Now, lawyers can't lie. If they know their client is, lying to them or saying something, they can't go and lie and say the opposite in the public. But if they believe their client, and that is their opinion based on what they know. Third, the April 27th Waldman statement viewed in context is a non-actionable statement of opinion insufficient to support a claim for defamation. So, can't hold Johnny accountable for what Waldman said. Waldman didn't act, even if you could, Waldman didn't act with actual malice. Therefore, not all the elements of defamation have been met. And third, in context, which they did not allow Johnny Depp's team to present them in context, it was clearly an opinion, which is very similar to Amber Heard's arguments. Assignment of error. Trial court erred in denying the motion for summary judgment because, again, Waldman was an independent contractor. Clear and convincing evidence didn't show that he acted with actual malice, and the statements aren't actionable because they are an opinion. All right, then they erred in denying a proposed jury instruction, and they erred in excluding evidence, the full unredacted version. So they should have let the full version in of the article that gives the context as to why Adam Waldman said what he said the way that he said it. All right, statement of facts. In connection with her counterclaim, Ms. Heard contended at trial that Mr. Waldman, acting as Mr. Depp's agent, defamed her in 3 statements. The first was quoted by the Daily Mail and stated that she used fake SV allegations and promoted SV hoax. The second was that Ms. Heard's allegations were a hoax. The article also included a quote from Ms. Heard's attorney that we believe Amber and we believe in Amber, a summary of both Mr. Depp and Mr. Heard's sides of the dispute. The jury did not find those 2 statements to be defamatory. But here we go. The April 27th statement. The sole statement on which the jury found in favor and Ms. Heard's favor. Here's the clip and the snippet that they pulled out, which is really important because they said out of context makes this a loser as well. Exclusive. I need to report an assault. Listen to 911 call made the night Johnny Depp and Amber Heard had a blowout fight that ended their toxic 18-month marriage. But both claim that tape backs up their version of the events. The April 27th article describes a recording phone call to the police on the night of May 21st, 2016, a date on which Ms. Heard alleged Mr. Depp threw a phone at her and roughed her up in the apartments at the East Columbia building. The April 27th article comments that Heard's attorney says phone records and police department logs vindicate Heard's account of the final shocking episode of DV she endured before filing for divorce. Whereas Depp's legal team say this recording does the precise opposite. However, by raising discrepancies in the various accounts Heard and her allies have given of the notorious dust-up. And it details Ms. Heard's various allegations about the abuse she claims to have suffered on May 21st, 2016, noting that the domestic violence case ultimately fizzled when the two LAPD officers who responded at 8:27 call said they never found any evidence of a crime. We saw their depositions. April 27th article further states that Depp's lawyer Adam Waldman said the various discrepancies proved that nothing Heard and her friends said about the May 21st, 2016 incident could be considered credible. It sets out that Waldman's purportedly defamatory statement, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. That's true. So Amber and her friends, this is the part, spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. The April 27th article also includes quotes from Mr. Waldman and Ms. Heard did not include in her defamation claim. Like this, quote, but even this didn't have the desired effect because two domestic abuse trained LAPD police would later provide a pair of sworn depositions saying they saw no evidence of a crime. These lies about who made the calls and when are just the tip of the iceberg, as the evidence will show in court. Finally, it presents a contrary view, quoting Ms. Heard's attorneys at the time. Heard's legal team rejected those allegations as fantasies. Mr. Depp's representations about the 911 calls on the night of May 21st, 2016 are false, and Mr. Depp and his lawyers should know better, said her attorney, Roberta Kaplan. All of the evidence, including the sworn testimony from multiple witnesses, phone records, and police department logs, are consistent with the truthful account given by a witness favorable to Ms. Heard. So what's interesting about all of this is that, if we're being honest, the rest of that article talking about the LAPD trained law enforcement officers, the 911 calls, the police reports, they didn't find any damage to her face or major damage to the apartment. That's kind of exactly what this jury determined after seeing all that evidence too. The jury also determined that that wasn't DV that night. Right? And by leaving out this context, the jury kind of exactly agreed with Adam Waldman and kind of ended up coming to the same conclusion as Adam Waldman. Now, they didn't come to the conclusion that her friends roughed up the place and that they got their story straight, but they did come to the conclusion that Amber Heard's DV stuff was a hoax and that she was doing it to try to trap Johnny or try to get Johnny. Very interesting to me. And he clearly was relying on evidence that he had to form this opinion. To me, which we said from the jump. We literally said this during the trial. Evidence relating to the Waldman statements at trial. All right. Ms. Heard presented no evidence at trial that Mr. Depp was personally involved in directing or making any of the three Waldman statements. Indeed, Mr. Depp testified that he had never even seen the Waldman statements prior to the filing of the counterclaim in August of 2020. Mr. Waldman has a professional license, is the owner and managing member of his own law firm, and provides legal services to his clients. He was retained by Mr. Depp in October of 2016 and still represented him at the time of the trial. Their relationship is attorney-client. He's represented him in various matters, and he testified that while he believed he had some knowledge of the conduct of Mr. Depp, he never personally witnesses any interaction between them prior to his representation in 2016, which was after their separation. So this is interesting because, as you remember, objection, attorney-client privilege. Objection, attorney-client privilege. So we didn't get a lot of information from Adam Waldman, and we got exactly zero evidence that Johnny Depp told him to say this or even that Johnny Depp was the source of information that Adam Waldman had to get and form this opinion. He referenced police officers, police reports, police depositions. That's what he referenced. Very interesting. Mr. Waldman testified that he made each of those statements. Ms. Heard did not present any evidence on whether or why Mr. Waldman believed each of his specific statements in response to a more general inquiry. And again, they already knew the answer because it was in the article. Mr. Waldman testified at length on why he believed Ms. Heard's allegations against Mr. Depp were false, describing physical evidence and identifying multiple witnesses whose testimony he believed contradicted her allegations. He's a lawyer. He understands how this stuff works. He also testified that he filed a claim with LAPD against Ms. Heard for perjury about false claims she was making to law enforcement about Johnny Depp. So let's talk about some argument here. Standard of review. I guess we can read it. In reviewing a ruling on a motion for summary judgment or motion to strike, the court normally considers the relevant portions of the record in light most favorable to the non-moving party and draws reasonable inferences in favor of the non-moving party. However, an appellate court in Virginia on the issue of punitive damages, or where actual malice must be proven, must independently decide whether the evidence in the record on appeal is sufficient to support a finding of actual malice by clear and convincing proof. In addition to the questions of law, they're subject to de novo review, which means as new. Whether allegedly defamatory statement is an actionable statement. Let's just get to the discussion. Mr. Waldman is an independent contractor. Okay. So what do you guys think? Do you think Adam Waldman is an independent contractor, or do you think he should be considered an employee? Let's take Johnny Depp out of the context, right? But just think about a lawyer. When you hire a lawyer, do you think they're an independent contractor or an employee? I know I have my feelings. Ms. Heard presented no evidence at trial that Mr. Depp was personally involved in directing or making the Waldman statements. Instead, she chose to pursue a pure vicarious liability claim. Proposed jury instruction on her counterclaim, which the trial court adopted and gave it to the jury, were based solely on a vicarious liability theory and did not require a finding of any conduct by Mr. Depp in connection with the Waldman statements. Again, she never tried to prove that Johnny Depp directed this. That claim fails on a threshold issue, whether as a matter of law, Mr. Depp can be held liable for the intentional tort of defamation based solely on statements made by his attorney on a pure agency theory. In the context of vicarious liability, Virginia has long recognized the distinction between servants and independent contractors and follows the well-established rule that a principal is generally not liable for the tortious conduct of an independent contractor. And that is true pretty much everywhere. Now, they're going to use the word servants and masters in here, like old Virginia law from 1940. It's pretty gross language, but I in today's connotation, the definition, I believe, would be like employee. So somebody that's an employee and controlled by you, you control their whereabouts, what they wear, what they do. They can't work for a bunch of different other people. They don't choose their hours. They don't bring their own tools to be an independent contractor, but a lot of it uses servants in here, which is all right. In Virginia, where are we at? Generally not liable. In Virginia, the doctrine of respondeat superior imposes tort liability on an employer for the negligent acts of its employees, i.e. its servants, but not for the negligent acts of an independent contractor. And that's everywhere, right? So if you have an employee that hurts somebody on the job, you can sue the employee and the employer. If you have this is interesting, sometimes it happens in bouncers at clubs, whether they're employees or independent contractors, and they beat somebody up in the line. Can you sue the club, or can you just sue the bouncer personally? Somebody that's driving an employee vehicle, is it their own vehicle? Do they make their own hours? Are they an independent contractor? Or are they basically owned and operated by the company and the vehicle is, and then you can sue the employer? That's how respondeat superior works. And everything you could have sued that employee for, you can also sue the boss for. Declining to adopt an exception to this rule for the tortious actions of an independent contractor who was an ostensible or apparent agent. The theory on which the master is held liable for his servant's conduct is based on the right of the master, actual or potential, to control that conduct and to see to it that negligent acts which cause injury to others do not occur. If the relation between them does not give the employer that power, then he should not be held responsible for an occurrence over which he had no control. Meaning, if Adam Waldman could only do what Johnny Depp said, when he said it, how he said it, and the way he said it, if that's how their relationship was, then maybe he is an employer. Maybe Johnny Depp should be liable. But if Adam Waldman can do things his own way to do a job for Johnny Depp that Johnny Depp hired him for, and he controls the way and when and how he does things, then Johnny Depp should not be held liable for that. I think that's like common sense to me. And trust me, that's how lawyers work. You can't tell me how to handle your case. You could say, this is my issue. Can you help me with it? Do you know how to help me with it? If you knew how to do it yourself, why would you hire a lawyer? If you were going to tell me how to do it, why would you hire a lawyer? This is bad precedent for legal representation. Really bad precedent. If the relation, if the relation between them does not give the employer that power, then he should not be held responsible. In assessing whether a person is an independent contractor, courts consider 4 factors: selection and engagement, payment or compensation, power of dismissal, and power to control the work of the individual. The 4th factor is the power to control was determinative here. Mr. Depp has not been able to identify any Virginia Supreme Court authority squarely considering the specific issues of whether an attorney retained in connection with litigation is an independent contractor. So that's why it's kind of a novel, new issue, right? Virginia Supreme Court has never decided this specifically. And I think one of the reasons they haven't decided it is because who would think that this is how you would do this and this is how it would work? And 2, whether the principle limiting liability for conduct of an independent contractor applies in the principal agent context, specifically with respect to the attorney-client relationship. Notably, the Virginia Supreme Court has cited with apparent approval the restatement approach, which limits liability of a principal for the actions of a non-servant. However, although other jurisdictions are not uniform, the majority rule and the rule that should be adopted by the court is that an attorney retained by a client for litigation, though undoubtedly an agent of the client in the litigation, nonetheless stands in the capacity of a non-servant agent, example, an independent contractor. And therefore, the client is generally not vicariously liable for the lawyer's misconduct, absent exceptions to the general rule that are not present here. Okay, so what Amber Heard stated is, the Virginia Supreme Court cited with apparent approval the restatement approach, which limits the liability of a principal for the actions of a non-servant. So even what they cite limits it. But the majority rule says no way. Although the authorities are not unanimous, which is all you need to know, that there's going to be other cases out there that disagree with some of these cases. Most other jurisdictions that have considered the issue have concluded that attorneys retained in litigation act as independent contractors, and those jurisdictions have accordingly imposed limits on the client's liability for tortious acts by their attorneys. The weight of authority provides that a client generally is not vicariously liable for its attorney's torts, absent evidence that the client directed, controlled, authorized, or ratified the attorney's alleged tortious behavior. And that's the important part, right? We're not saying you can never be liable for what your lawyer does, and there are some very powerful people that do control what their lawyers do and say. And in those situations, if they could prove that Johnny Depp told him to do this, directed him to do this, forced him to do this, then it may be different. But there was no evidence of that. And I was pounding the table about that while Waldman was testifying, and after his testimony, they got nothing out of it, which is why I didn't think she would win. But I think they were trying to give a compromise verdict, if I'm being honest. The law firm attorney working with a client is nonetheless an independent contractor and not an employee of the client corporation. Independent counsel retained to conduct litigation in the courts act in the capacity of independent contractors. Now, they're pulling this out of a lot of cases. I didn't read all these cases. My guess is it's not the actual rule of law from every case, but it's dicta, as we say, D-I-C-T-A, which is kind of like things we can use that this is how the court views it. And in these situations, when we're trying to define independent contractor, we can look to other cases and see how the court used this language and whether or not they saw attorneys as independent contractors or employees. And that's kind of how you do it. It's not necessarily a rule of law saying lawyers are always independent contractors. Under traditional master-servant law, the attorney was an independent contractor. We think the unique attorney-client relationship should not be analyzed merely with reference to ordinary agency law. A general retention of an attorney to do all things necessary to pursue a claim or defense should, in legal contemplation, mean the attorney has authority to do all things legal and proper, not otherwise. We will not presume a direction or authority or permission to commit a tortious or illegal act inheres in the actual attorney-client relationship. When, as here, an attorney acts pursuant to the exercise of independent professional judgment, he or she states or acts presumptively as an independent contractor whose intentional misconduct may generally not be imputed to the client. There is a vast difference between an employee agent and a non-employee agent. The non-employee agent is generally nothing else but an independent contractor. Attorneys generally are not subject to their client's actual control or direction. In our fee agreements, we literally say, you cannot control the method and mode of our operation and how we work. We will make the strategic decisions in your case. If you do not trust us to do that, you probably should not hire us to be your lawyer. Unless a client is implicated in some other way than merely being represented by the attorney alleged to have committed the intentional wrongful conduct, the client cannot be liable for the attorney's conduct. Sue Adam Waldman. There are sound reasons why multiple jurisdictions have concluded that vicarious liability should have a limited application in the attorney-client relationship. Lawyers, as legal professionals, typically are not subject to their client's control with respect to the matter in which they provide their services. Absolutely. If clients cannot control the details of their attorney's work, it makes little sense that the clients should nonetheless be held accountable for their attorney's tortious acts. Attorneys generally are not subject to their client's actual control or direction. Indeed, most clients have an attorney because they are unfamiliar with the law and want an attorney to guide them through the intricacies of that field. As professionals, attorneys are deemed responsible for their own acts. And as in this case, most clients have legal recourse against the attorney and their law firm for their actions. Although a lawyer is subject to the client's direction with respect to the goal of the representation, it is the lawyer who has wide discretion as to the means by which those goals are achieved. Exactly. It's interesting to think, like, would this be legal malpractice, like committing defamation on your client's behalf? Interesting to think about. In every American jurisdiction, including Virginia, a lawyer is required to exercise independent professional judgment and is subject to independent professional and ethical obligations. A lawyer shall abide by a client's decisions concerning the objectives of representation and shall consult with the client as to the means by which they are to be pursued. In representing a client, a lawyer shall exercise independent professional judgment and render candid advice. Further, a lawyer is prohibited from advancing frivolous arguments on behalf of the client. He can't go lie. He can't go commit crimes. He can't go commit defamation, right? And a lawyer has a duty of candor to the court and is permitted to refuse to present evidence on behalf of a client that the lawyer reasonably believes is false. We've been over this. We've talked about what do you do if your client wants to lie on the stand. We've done videos on it. A lawyer is, in sum, required to exercise professional expertise beyond that of the typical client. Does that mean lawyers never lie? No. But it means lawyers know they can't. It is unlawful and unethical for them to go lie in public about these things. And the proper channels are make a bar complaint, not sue the client for defamation. We have proceedings in place if Adam Waldman really did go lie in public, which I'm not saying he did, but if he did, this does not seem to be the proper procedure, and it's not how it's done all over the country. There are, accordingly, substantial limitations on the client's ability to control the activities of the lawyer. In any case, the typical client who generally lacks legal expertise cannot monitor the conduct of the lawyer for wrongful activity. The lawyer's conduct may be binding on the client with respect to positions taken in litigation, meaning if a lawyer makes an offer, they accept, and it was a misunderstanding or the client didn't necessarily want it, you can potentially hold the client to that offer. But to hold the client liable for an attorney's intentional tort goes a step too far and is fundamentally inconsistent with the logic behind independent contractors' principles of limited liability. I agree. It's totally illogical. Whether this was Johnny Depp or whether this was Amber Heard, you guys know. This is exactly what I was saying. It makes no sense that when they were calling them the Waldman Depp statements, I had a problem with it. When they read the jury instruction, I had a problem with it. When Waldman was on the stand, I had a problem with it. Like, how did they even know this came from Johnny Depp? And they didn't even try to prove it because they couldn't. Here, the established evidence that Mr. Waldman was retained by Mr. Depp to act as his attorney and that he acted in the capacity for several litigation matters, including the initial stages of this litigation. Other facts that underline Waldman's role as an independent contractor only are that he is the managing partner of his law firm, has clients other than Mr. Depp, and offers legal services to other clients. We're nobody's employee. We are nobody's employee. Nobody tells me what to wear. I should say, obviously, there are lawyers in the firm and employees in the firm, but I'm saying a client that hires me, they don't tell me what to wear. They don't tell me what to do. They don't tell me how to talk. They don't tell me how to act. They don't tell me what motions to file. Now, I may say, hey, we can file this motion. Here's the bet, the risks, the reward. If we do this, here's the possible downfall. I tell them all of that and I give them advice, but they don't say, use this language, quote Shakespeare here in your motion. Be nasty in your motion. Now, sometimes clients say to do that, but I don't listen to it. I don't take on the tone and aggression of a client in the case. I handle the case the way that it needs to be handled appropriately, ethically, and morally. And if clients don't want ethical and moral representation, they know not to come here. Ms. Heard presented no evidence that Mr. Depp was personally involved in directing or making the Waldman statements. We know that. We've heard it 1,000 times now. In fact, the uncontroverted evidence was that Depp never even saw them. Okay, we went over that. No one appears to dispute that Waldman did not act in any capacity for Mr. Depp other than as his attorney, and he should be considered an independent contractor. Because of this, the uncontroverted evidence established that Mr. Waldman was only an independent contractor. All right. Ms. Heard presented no evidence of actual malice. Let's get to this, the next part here. Actually, let's take a break. Let's answer some questions. You guys, have you asked any questions here? I haven't been watching the chat a ton. Erica Ramsey, why would he appeal? Didn't he essentially win? Yes, and he made it clear he's only appealing the one little count that he lost. Jamie Heartbeat is a new member, as well as Anne-Marie Holahan. Beverly, are jury and trial court synonymous? No. Trial court usually means the judge. If the trial court made a decision, that's the judge. If the jury made a decision, that's the jury. John O'Rourke, were you surprised that JD's legal team didn't call Waldman to the stand? No, because if Johnny Depp would have waived attorney-client privilege, it could have gotten messy. I think they thought they were going to win just based on this argument because it doesn't make sense. How are you going to hold Johnny Depp liable for this when you don't even know Johnny Depp told him to say it? Julie1969, I got jumped in a bar in 1992. I sued the bar. Yeah, getting jumped in the bar is different because they didn't provide proper security. I'm talking about when the actual security guard beats up someone in line or while they're throwing somebody out, breaks their collarbone or causes a concussion or brain bleed, things like that. Teresa, I'd like for him to win the appeal, but I don't see it happening. It's very difficult to win appeals. Very difficult, but I think he's got a good argument. If I had to put money on it, I would say no, but he's got a good argument. Nikki, I think JD will win on this. Okay. All right, well, let's get back to it. Ms. Heard presented no evidence of actual malice. Even if the court were to conclude that Mr. Depp could be held liable for Waldman's statements, trial court erred in denying the motion for summary judgment because there was no evidence of actual malice. As noted above, Heard chose to pursue the theory of vicarious liability against Mr. Depp. She did not ask the jury to find that he was directly involved. Heard all that. It's necessary to prove all of the elements, which includes actual malice. That is the requisite intent they mention here. So in order to establish actual malice, the plaintiff must demonstrate by clear and convincing evidence that the defendant realized that his statement was false and that he subjectively entertained serious doubt as to the truth of his statement. And this is the big part. Let me know. Do you think, and John, if we can put up a poll, in your heart of hearts, if you're going to be hooked up to a lie detector test, or if we hooked up Adam Waldman to a lie detector, do you think he believed the statements that he said? Do you think they were his true opinion? That Amber Heard actually did rough up that penthouse, spilled some wine, and got her story straight? Do you believe that Adam Waldman believed his statements? Yes or no? If we don't get a poll up, just put Waldman believed or he didn't believe. He was just trying to get a shot for his client across the bow. See what I did there? Pirates of the Caribbean. Importantly, actual malice is a subjective standard that examines the actual beliefs of the person publishing the defamatory statement at issue. Consequently, actual malice is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. Rather, there must be sufficient evidence to permit the conclusion that the defendant in fact entertained serious doubts as to the truth of his publication. This is why usually this stuff is so difficult, but if we're looking at the world today and we're seeing Johnny Depp and Amber Heard, Alex Jones, Kanye West, also, what's the YouTuber with Cardi B? all sorts of statements, juries are finding actual malice. And it's hard to know what a person knows, what a person thinks, what a person actually believes to be true. It's very difficult to prove that, which is why historically defamation has been much more difficult to win than it seems to be currently. Thus, for instance, a mere failure to reasonably investigate the truth of one's words is not enough to establish actual malice because it does not establish subjective knowledge of falsity. Meaning, yeah, I think the sky is red today. I don't even have to walk outside to see that. I just think it is. You don't have to investigate. Indeed, in the context of, or I guess that wasn't a good one. A good one is, I think X politician, insert name here, is a total fraud. I think X politician is doing a horrible job. Opinions, right? I don't have to investigate and see what's their approval rating and how have they done for their constituents. I can just have that opinion. Indeed, in the context of actual malice inquiry, a duty to investigate the accuracy of one's statements does not raise until the publisher of those statements has a high degree of subjective awareness of their probable falsity. So once you know, okay, wait, this is probably not true. If you never think that, if nobody ever gives you an indication that what you're about to say is probably not true, you don't really have a duty to do a big investigation. Thus, to succeed on her defamation claim, against Mr. Depp, Ms. Heard was required to establish by clear and convincing evidence that Waldman either knew the statements were false or he subjectively had a high degree of awareness that they were probably false. And you may ask this question. What does that mean? When would that come? Okay, so did he believe his own statements? Did he believe the statements? I think it's supposed to mean, did Adam Waldman believe his own statements? 250 votes in the first minute. 94% of you said that you think he believed his statements. 6% said no. So keep voting on that so we can get a little bit more of a sample size than 250 people with 2,000 people in here. And we should have 2,000 likes as well, right? Because everybody's hit that like button. But people may ask, so how can you get an awareness that they were probably false? Some of you may say, well, maybe Amber Heard. There's a motorcycle driving by. But maybe Amber Heard, when she said that they were true, maybe Adam Waldman should think, wow, is what I'm saying false? But I think Adam Waldman would have a good argument to say, Amber Heard says a lot of things that aren't true. And the jury actually found that a lot of what Amber Heard said under oath was not true. So why would that give me an indication or an awareness that they were probably false? It has to be more than that. Clear and convincing evidence is that measure or degree of proof which will produce in the mind of the trier of fact, which is the jury, a firm belief or conviction as to the allegations sought to be established. And this is the problem for Johnny Depp. This was put before a trier of fact, a jury, and the jury decided that Adam Waldman did have all of the elements necessary for defamation, including actual malice. And this is why, if I had to put money down, I would say I think Johnny Depp's going to lose this appeal. Because a jury did get this information, and they decided that there was actual malice, and that Johnny Depp was vicariously liable. So we can disagree with that. And I think their best argument against it is that there was literally not clear and convincing evidence. There was no evidence of what Adam Waldman knew or didn't know, or that he knew it was probably false. There was no evidence that he knew it was probably false. That's why I was saying I think it rises to the level of no reasonable jury could ever determine that there was actual malice here. On review, appellate courts must exercise independent judgment and determine whether the record establishes actual malice by clear and convincing evidence. And here we go. Ms. Heard presented no evidence, much less clear and convincing evidence that there was actual malice. All evidence adduced at trial pertaining to Mr. Waldman's state of mind when he made those statements was that he believed they were true. And 96% of you agree. And a lot of you in the chat are saying, I still believe what he said was true. So if you still believe it, I think there's a chance he believed it when he said it. He's a lawyer, a very good lawyer, well-respected lawyer, I should say. So he's just going to go lying in the public? I don't think so. Again, he filed the claim with LAPD and clearly believed those statements, according to Johnny Depp's lawyers. In context, the Waldman statements are not actionable because they're opinion. Even if the court believed that he could be liable, it's still fundamentally defective because read in context, it's not actionable. And they should have granted Depp's motion for summary judgment. Pure expressions of opinion, not amounting to fighting words, cannot form the basis of an action for defamation. The First Amendment to the federal Constitution, Article 1, Section 12 of the Constitution of Virginia, protect the right of the people to teach, preach, write, and speak any such opinion, however ill-founded, without inhibition by actions for libel or slander. Now, I think nowadays that might be getting some pushback, and I think it's a lot less broad than it used to be. Conversely, however, there is no constitutional value in false statements of fact. Thus, in an action for defamation, and that's where we kind of talk about, was this a factual statement or was it an opinion? And it looks a lot more factual out of context. Thus, in an action for defamation, the court must resolve as a threshold matter whether an alleged defamatory statement is one of fact or of opinion. A statement of fact is one with a provably false factual connotation, or which can be interpreted as stating actual facts about a person. However, even a provably false statement is not actionable if it is plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts. So what do you think? Do you think this Waldman statement was opinion, or do you think it was fact? Maybe we can get another poll up. Was the Waldman statement opinion or fact? Importantly, in assessing whether allegedly defamatory words are fact or opinion, the court must examine them in context, with the aim being to interpret them as other people would understand them and according to the sense in which they appeared to have been used. In the totality of the circumstances, how they were used in that totality. Thus, in considering whether a statement's audience would understand it as a statement of fact or opinion, courts consider such factors as the forum in which the allegedly defamatory statements were uttered and whether an audience familiar with the forum would expect to hear an opinion. If a statement is made in a forum in which a reader would be likely to recognize that the critiques represent the highly subjective opinions of the author and relates to inherently ambiguous subject matter about which reasonable minds could draw different conclusions, then the general context in which the statements were made negates the impression that they imply a false assertion of fact. Courts also consider the degree to which the statement's audience is familiar with the other underlying facts and therefore able to assess defamatory statements for themselves, concluding that statements were opinion when made to reporters who were familiar with the long-running dispute among the parties and knowledgeable about the underlying facts and therefore understood that the defendant was presenting his own opinion. Seems like spot-on case law, but again, jury made their decision. In addition, but that's why they're kind of hammering some of the judicial decisions, saying this shouldn't have even gotten to a jury. That's why they talk about the jury instruction, the motion for summary judgment as a matter of law. That means the judge made the wrong call, not the jury. In addition, courts consider whether the statements were made in the context of a debate or a controversy. Seems like it was, because statements made in the heat of a debate are more likely to be understood as their audience as expressions of opinion. And that's why they were saying it was a quote from Amber Heard's lawyer, a quote from Johnny Depp's lawyer, a quote here, a quote there. Courts also consider the identity of the speaker and whether the speaker's biases are known and disclosed to the audience. So if you represent somebody, you're probably biased towards them. The most unsophisticated recipient of such a claim made by one competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, which you have for your clients. Further, courts can consider whether the speaker claims to have personal knowledge or is merely drawing inferences about events he does not claim to have witnessed. Clearly, he didn't witness. No liability where there was no claim to firsthand knowledge of facts, and the context and tenor of the article thus suggest that it reflects the writer's subjective and speculative supposition. Again, the quote, And when read in isolation, it could arguably be interpreted as a factual statement. But in context, it's a non-actionable opinion. It was presented as a statement by a lawyer in the context of litigation and represents only one side of a heated debate. It was made to a reporter who presented quotes from both sides of the debate and was necessarily aware of the facts that were hotly disputed, as we saw in court. And, oh, this is interesting. I missed this the first time I skimmed this. Heard's lawyer actually said that Waldman's statements are fantasies, meaning not facts. Interesting. Mr. Waldman never claimed personal knowledge of what happened on May 21st. No one disputes that. He was speaking as a legal advocate, offering his own interpretation of disputed evidence. That seems so clear to me. Unlike Amber Heard's statements of facts with the DV, the SV, things like that, what she had to endure, the specific events, he said, she said dispute cannot be defamatory. Sounds like what it was. No liability where there was no claim to firsthand knowledge of the facts. Context and tenor again. No liability in defamation for statements by an attorney that were a subjective assessment of evidence which could not have been objectively characterized as true or false at the time, as it depended largely on his own perspective and assessment of the weight of the available evidence. No liability for defamation for accusing a plaintiff of lying when a reasonable person would have perceived the accusation as pure opinion based on the defendant's subjective understanding of the underlying scenario. Which it seems like what happened here. He did throw some facts in there about specifically what they did. It wasn't just a hoax or a lie. They got together, story, lawyer, publicist, spill wine, roughed the place up. In context, it's clear that Waldman's view was a subjective interpretation of hotly disputed evidence. All right, let's look at the jury instruction. It's reviewed under an abuse of discretion standard. In reviewing a trial court's decision to refuse a jury instruction, the evidence is viewed in the light most favorable to the proponent of the instruction. Whether the content of the instruction is an accurate statement of the relevant legal principles is a question of law, like all questions of law, and is subject to review de novo. If a proffered instruction finds any support in credible evidence, its refusal is reversible error. Meaning, you can have a lot of instructions. Some of them, you may be like, we don't really need them. But if it has any support in credible evidence, it could be reversible error for not allowing it. Jury instructions are important. I know they're boring when we read them, but it takes a long time. We were just prepping them for a trial that's going on Monday. I'm not trying it in the office, but two of our other lawyers are. And the jury instructions just take forever going back and forth. Plaintiffs proposed, defendants proposed. Usually we can agree to them, but usually there's one or two we don't agree on. And if the judge does not allow one that has support and credible evidence, it could be reversible error. Evidence was presented from which the jury could have found that Mr. Waldman was an independent contractor. At trial, Depp's proposed jury instruction. Before we get here, let's see. Interesting. So this one's a little bit closer. Was the Waldman statement opinion or fact? 80% said opinion, but 20% said fact. That's good. See, you guys are being honest here. That's good. And that's over 300 votes. All right. An independent contractor is a person who engaged to produce a specific result, but is not subject to the control of the employer principal as to the way he brings about that result. If you find that Waldman was acting on Mr. Depp's behalf, but was not subject to Mr. Depp's control as to the manner, method, and or means by which Mr. Waldman worked, you must find that Mr. Waldman was an independent contractor. That was the jury instruction they wanted. An outside lawyer retained by a client in connection with litigation is an independent contractor. A person who hires an independent contractor is not liable for the independent contractor's actions. If you find that Waldman was an independent contractor of Mr. Depp instead of as an employee, you may not find Mr. Depp liable for Mr. Waldman's conduct. The court denied these instructions, and my guess is she denied the instructions because she didn't think that's the case that they had here, that this was as Johnny Depp's lawyers have set it out in this appeal. But if the appellate court agrees, then they definitely should have had this instruction at the very least to make sure the jury was making the right decision as a matter of law. And if they did find that he was that he was an employee, fine. So be it. They found that there was evidence that he was an employee, but they didn't even get this instruction, which was an issue according to Depp's lawyers. Mr. Depp incorporates by this reference and will not repeat at length the arguments set forth above regarding Waldman's status as an independent contractor. Thank you. So we don't have to read it again. In sum, since the evidence supports a finding that Mr. Waldman was an independent contractor, his allegedly tortious conduct cannot be imputed to Mr. Depp, absent evidence of additional involvement by Mr. Depp in making defamatory statement, which was not presented at trial. The evidence at trial established he represented him solely as a lawyer. We do not have to read that again. The trial court erred in excluding the full articles containing the Waldman statements. So this is the unredacted articles that Johnny Depp's team wanted to put in to show the back and forth, which we'll read here, that they didn't allow them to. And I didn't hear all these pretrial rulings, so I don't know why the judge did not allow this in as a rule of completeness or to understand the context. To me, that seems weird. I'm sure she had a good reason for it. I just don't know what it is. At trial, Mr. Depp sought to introduce unredacted copies of the 3 Daily Mail articles containing each of the 3 Waldman statements. Trial court excluded the articles as hearsay, but they're not going for the truth of the matter. They're providing context to the actual statements. They don't need to be true. And actually, they could have been proof as to why it was not actual malice on Adam Waldman, that even if what he said is not true, it's what was in his head, right? And what he was thinking. But I guess you could argue that that is going to prove the truth that he believed that. It's kind of an interesting argument. I would like to flesh that out a little bit, whether or not it would be considered for the truth that Waldman actually believed that opinion and that he was not lying, and that's why they didn't come in, versus providing context and sometimes the effect on the listener. That's what I think I would argue. I don't know. I'd have to think about that some more. That's really interesting. As set forth in Section 4, in assessing whether a statement is actionable for defamation, context is paramount. While the context in which Waldman made the original statement to reporters is relevant, the contents of the article is also relevant. For instance, the first full articles in which the Waldman statements appeared are relevant to how the reporters and ultimately the readers understood Waldman's statements as presenting one side's interpretation of evidence gathered in a hotly contested litigation. We already heard this. Full article, it appeared relevant to assess what, if any, damages Ms. Heard purportedly sustained from them. Again, because it also had quotes from her lawyer, so that's true. How did it actually affect her? In assessing whether Ms. Heard assessed any damages from the Waldman statements, the jury should have been able to consider that the Waldman statements were buried at the bottom of a salacious tabloid article and surrounded by substantial additional commentary about Mr. Depp and Ms. Heard, little of which was flattering to either of them. The court erred in excluding the article. So basically what they're saying is, if the jury would have seen this full article, they would have seen Ms. Heard was probably going to be hurt by this article, whether or not they had Adam Waldman's comments in it. But then I think we may have had to talk about whether or not the theme of the article and the tone of the article was because of the Waldman statements, right? And that could kind of get confusing. So in conclusion, the court should reverse the judgment on Ms. Heard's counterclaim as to the Waldman statements April 27th. We made it through. We made it through. Those are always brutal. Brutal to get through. And look, we're almost at the hour mark. How about that? Let's answer a few questions here. Christy RN. Do you think maybe the jury didn't want to open the door to AH's friends being liable, and that's why they awarded to her on that one claim? Honestly, that's not what they were deciding, right? It's almost like that's not my job type of deal. They could have ruled in Johnny's favor just because they said, even if the statements were false, I think Adam Waldman believed them. I think Adam Waldman believed them to be true. Or he was acting on his own. He wasn't acting on Johnny's behalf. Those weren't Johnny's statements. There's a lot of ways that they didn't have to rule in Amber Heard's favor. I think they wanted to rule in Amber Heard's favor just a little bit. Just enough to make this compromise verdict. I really do. Brianna, will we ever see a day when monies exchange hands? That's a great question. That is a great question. And will we know how much when it does, if it does happen? Kay and Stitch, what's your opinion on NK Lawyer getting investigated? NK Lawyer. I don't know what NK Lawyer is. Sorry. Oh, NC, Nicholas Cruz. If I did see an article that his lawyer is getting investigated, the one that put up the middle finger, and I think that's absolutely appropriate. That's unprofessional, unethical behavior in court, and I think the Florida bar should have something to say about it. And she may not be the only one that has issues coming from that trial. An organization that my dad's a member in, a past president in the Florida Association of Criminal Defense Lawyers, had something to say about the judge in that case. If you guys want me to break down the letter FACDL, the Florida Association of Criminal Defense Lawyers, drafted about the Cruz judge, the Parkland shooting trial judge, hugging prosecutors at the end of the case, how she acted in sentencing, how she acted throughout the trial, I got some hate for my comments about it. Again, none of this has to do with the victims. Victims can say and do whatever they want. It's the judge that has to make sure the rules in the courtroom are handled appropriately. And I was not on my own in thinking that I think the judge made some mistakes. I'm not saying I hate her. I'm not saying she's horrible. I'm not saying anything like that. I just think she made some mistakes in a very high-profile, tense, passionate trial. And I can understand why it was difficult. And I don't envy her position. I will say that as well. So if you guys want that, let me know in the comments. In 06, Waldman statements are a very close approximation of what appears to have actually occurred. Cops came, saw nothing, left. Cops called again, reported seeing spilled wine, a few things ruffled. And it's what the jury found, right? It's what the jury determined. That Amber Heard, it was a hoax. If she says that something happened that you rule and choose and say in a court of law, it actually didn't happen, you're kind of saying the same thing, just without some of the details. Which again is why I think the context really was important. Kat Yarb, I think there should have been a jury instruction explaining agency and independent contractor. I don't disagree. Give them more information. Let them know what they're supposed to be deciding. Nicholas, OT, do you have a Florida man story you can share? A Florida man story, like something wild that happened in Florida? Let me think. I'll leave this one up here and I'll try to come back. Tina, I may have missed it. Apologies. Joined late. Help me understand how JD would be held accountable for someone else's comments. If it's an agency theory and he's technically an employee, and like companies and bosses and employers can be held responsible for what their employees do in vicarious liability, that's basically the theory they went under. I don't agree with it, but that's how they got there. John O'Rourke, couldn't this all be settled with JD's legal team calling AW to the stand and simply asking him, did JD tell you to make these comments? I just don't understand why JD legal team did not call AW to the stand for this. There's a couple reasons, right? There's always strategy and you can second guess how you do things, but I think they felt like Amber Heard's team had no evidence of anything. So if they do put Waldman up there and he waives privilege and Johnny Depp waives the privilege, attorney-client privilege, and answers those questions, which they objected to those answers as attorney-client privilege, that opens the door to other things. You can't just waive it for some and not others to protect yourself from cross-examination. And I think they thought they were going to win because there's no evidence that really came out. And that's what I kept saying. He didn't actually say almost anything that was relevant to the causes of action in the case. DM, Waldman's statements were opinion, but somewhat true. I mean, so that's a double whammy as to why it shouldn't be defamation. Decibel Chaos. It seems so clear-cut to me. I really hope he wins this appeal. It's a long shot, but maybe. Peter, it's been a while since you live read. I know. I don't really miss it. What is de novo? It means looking at it anew. The facts are as anew, like they already haven't been decided yet. K and Stitch. Yes, please do that video. And I meant NC. Sorry, no problem. It took me a second to figure it out. But luckily, we're on the same page, which is why we can't cover every case. We've got to keep it to a certain amount that's manageable, and I can keep my arms around it and know which people you're talking about. Southern Mama, hey, can you give my son Logan a shout out? What's up, Logan? We are listening to you in the hospital with a possible broken foot. That stinks, Logan. I don't know how old you are, but when I was in high school, I broke my leg pretty terribly. A compound fracture, Joe Theismann type of injury through the skin, 7 surgeries. It was brutal, but we got through it, made it out on the other side, and we're a stick on the golf course because of it. Never really played golf before, but was forced out of football and all the sports I wanted to play because of this. I broke it playing football. So story time. Smash Lee. If you hired, do you consider yourself independent contractor or employee? Absolutely independent contractor. I'm not any of my clients' employees because you can't. If somebody's your employee, you tell them how to do everything that they're going to do. My clients couldn't possibly do that. Just like when I hire a general contractor to build me a house, he's not my employee. I can't even tell him how to build the house. I don't have all the tools he needs to build that house. Nicholas. Okay. Florida man story you can share. Oh, I really can't think of any right now. I can't think of any. I'm bad at going off topic here. when we're all focused in and we're an hour in. I apologize, Nicholas, but I'll try to get one for you on the next video. Okay. Right at the 1 hour mark. Have to take off. I appreciate all of you joining me as always. This was fun and kind of funny. The one I talk about tomorrow is kind of interesting and kind of funny as well, how Amber Heard is stateless. What does that mean? That she's stateless? What is happening in those cases? Is it going to be stayed? Should it be stayed? What are the insurance companies doing and saying? So check that out tomorrow night. But I appreciate everybody coming in. I appreciate everybody still hanging around for the Johnny Depp Amber Heard content. And if you do like it, please hit that like button and let me know if you want me to follow these cases or if they should go by the wayside, and we'll cover what's current. You guys let me know, because it's like choose your own adventure around here, right? The Lawyer You Know channel is like choose your own adventure. All right. Appreciate you all. Have a great weekend, everybody. I think it's daylight saving, so we're going to be changing our clocks at some point. I'll see you next week. Maybe I'll be in the chat tomorrow night for that video. It will not be live. I know a lot of people are always upset when it's not live, and I can understand, but usually we put live in the title when the video is live. All right.